We have breaking news out of the United States Supreme Court. The state of Maryland has filed its opposition brief arguing to the U.S. Supreme Court that the court should not take the Snope case involving Maryland's ban on so-called assault weapons, which, as you know, are just semi-automatic rifles. This is a major brief trying to persuade the U.S. Supreme Court to back off and let states continue to run roughshod over our Second Amendment rights when it comes to their banning AR-15s and banning of AK-47s and other semi-automatic rifles. Let's break down this submission by the state of Maryland, and let's discuss how good or bad it really is when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of a brand new law review article I encourage you all to read. Click on the link in the description of this video to get a free copy of it from the Georgetown School of Law. Specifically, the article was published by me in the Georgetown Journal of Law and Public Policy, and the title of it is Dangerous But Not Unusual: Mistakes Commonly Made by Courts in Post-Bruin Litigations. It is a discussion of how to apply the Second Amendment to the various controversy that we're seeing around the country, everything from arms ban cases to issues associated with age, restrictions on young adults and sensitive places, and so on and so on. It's about 60 some odd pages. Check it out. It walks everyone through it, including law clerks and lawyers and historians and scholars and anyone that has a reason to understand the Second Amendment. It walks them through it bit by bit, piece by piece, with detailed scholarly citations. So check it out. My article in the Georgetown Journal of Law and Public Policy. Link in the description of this video. All right, folks, so we have breaking news here. The state of Maryland has finally filed its opposition to the Second Amendment plaintiffs' petition for cert to the U.S. Supreme Court. For those of you, as a reminder, the Supreme Court doesn't have to take any case it doesn't want to as a general matter. People have to petition for cert, which means they are asking the court to take a case, which they don't have to take. They have that discretion. And the Second Amendment plaintiffs in the case of Snope have asked permission or asked for, they've petitioned the U.S. Supreme Court to get the Supreme Court to hear the case of Snope, which deals with whether or not the semi-automatic rifle ban in the state of Maryland is constitutional under the Second Amendment. You may recall a few weeks ago, the state of Maryland tried to get a second long extension of time to push this case into the following term, the next term, which would be 2025 through 2026 is the next Supreme Court term. Right now, we're in the middle of the 2024 to the 2025 Supreme Court term, which will end in June of 2025. But I'm happy to report, as we talked about before, that the U.S. Supreme Court refused to grant Maryland that additional extension of time, suggesting that the Supreme Court may very well be very interested in hearing this particular case of Snope in this term and settle once and for all the obvious question with an obvious answer that you simply cannot ban semi-automatic rifles in the United States if you're the government. It is not allowed under the Second Amendment and the clear precedent of Heller, which is the 2008 Supreme Court decision that explained you cannot ban handguns in the United States, including modern handguns in the United States, because they're in common use by Americans for lawful purposes. Now, the state of Maryland, filed in this opposition brief, says that there's no need to grant cert for several reasons. The first thing they argue is that this assault weapon question is a brand new issue, that they need to allow time for the courts to percolate and reflect on whether or not these bans on semi-automatic rifles is in various jurisdictions, Massachusetts, Illinois, Maryland, and the like, and D.C., whether or not they violate the Second Amendment in light of the Bruin decision. Now, you know, if you follow this channel and are the smartest person in the room when it comes to our Second Amendment rights, you know that the Bruin decision does not disrupt or cut back in any respect the 2008 decision in Heller. Heller created, after looking at the text of the Second Amendment and then the historical tradition of certain regulations and restrictions on banning guns, concluded that you cannot ban guns in the United States under the Second Amendment unless conceivably the arm is dangerous and unusual. And by extension, the Supreme Court said in Heller that because handguns were ubiquitous, They were commonly owned by Americans for lawful purposes. They were not unusual, and because they were not unusual, they could not be dangerous and unusual because they weren't unusual, and thus the D.C. ban on handguns fell by the wayside. And what's happened, of course, since then is courts like the Fourth Circuit Court of Appeals out of Maryland have been trying to sidestep this, and they are pretending that Heller is not the law of the land and Bruen is, when all Bruen did in 2022 was reiterate the Heller standard of text first, burden shifts to the government to show the existence, if there is one, of a historical tradition of some sort of firearms regulation. But the Supreme Court has already did that work in Heller and set forth the uncommon use test. Now, of course, Maryland is trying to dodge this and trying to justify and trying to support the terribly reasoned majority opinion by that en banc Court of Appeals decision in the Fourth Circuit written by Judge Wilkinson. They're literally saying crazy stuff. To give you one example, in their brief here, they literally argue that Heller never said that arms that are in common use are protected under the Second Amendment. But here's the amusing part. In their brief, literally in the same brief where they just made that argument, Maryland quotes Nysurpa versus Bruen in the Supreme Court with the following language. They literally write, this is not me, this is not even Maryland, this is Maryland quoting the U.S. Supreme Court, stating, quote, the Second Amendment protects only the carrying of weapons that are those in common use at the time, as opposed to those that are highly unusual in society at large. And they quote Bruen for that. In the same exact brief, Maryland is arguing that Heller never said that arms that are in common use are protected. You can't square those circles. That's internally inconsistent. And I promise you that the U.S. Supreme Court, with all their sharp law clerks up there, are going to pick up on that inconsistency. And of course, they actually know what Heller says because they're capable of reading it. Beyond that, again, Maryland tries to say there's no circuit split. They're trying to say, well, Supreme Court, you really only, take a case if there's a circuit split, meaning half the country says X, the other half of the country and the courts say not X, and then you resolve that split. Well, that's not always true, because there is often the case that the Supreme Court will take a case where there's no circuit split, but if it's particularly important, because it keeps coming up. I mean, we saw that in the case of some of the Trump cases, right? There's no circuit split in the Trump 14th Amendment case or the Trump immunity case. There's no circuit split in a lot of that stuff. And they took it anyway because they thought it was important. And here, as we've talked about it before, and I believe I'm one of the first people to say this, and I think now everyone gets it, there will never be a circuit split that I can tell in the United States. Maybe I'll be wrong, but there will never be a circuit split in the United States dealing with these quote-unquote assault weapon bans of semi-automatic rifles, because you never get a gun ban of AR-15s in the red states. You only get them in the blue states. And the blue states give rise, because of the political nature and the politicians and who becomes a senator there and so on, you generally get left-wing judicial activist anti-gun judges in the blue states. So you're only going to get blue state judges, as a general matter, ruling on blue state gun bans. You will never get red state judges knocking out gun bans at the Court of Appeals level, because there will never be gun bans in the red states to be knocked out. So you will never get a circuit split. And I can assure the U.S. Supreme Court, they are not dumb. They're very smart. They will get the point I just made instantaneously. They will understand this. Now, as to whether or not they're going to step into the breach and do something, I can't tell you this, but I am confident if the Supreme Court grants cert in the Snope case, we have a 99% chance of absolutely winning this case, because this is understandably the right way to interpret the law, is what I say this in common use test. And it's very good for us because, remember, it's not the only way we can win a gun ban case, but it's the easiest way to win a gun ban case. Now, let's go through some other specific arguments that Maryland made. One of the things they try to say is that AR-15 was never established as suitable for self-defense by the plaintiffs in this case. That's nonsense, because there's no burden to do so. Keep in mind that if you look at Heller literally said there was no finding of fact that handguns are good or bad or ugly or whatever. Heller simply said the following: for whatever the reason it is, Americans overwhelmingly choose to buy and own handguns for self-defense. There's no trial in Heller. There was no expert witnesses in Heller. There were no witnesses in Heller. There was no cross-examination in Heller. Nothing like that took place in Heller. Because the court says, well, obviously, these handguns are ubiquitous. We can take judicial notice. It's a legislative fact. We get it. And they're ubiquitous. And this is why Americans choose them. We don't know why they choose them. We don't care why they choose them. But we know that they overwhelmingly do so because there's millions and millions and millions and millions of people own millions and millions and millions of handguns. And for whatever the reason, that's enough to show they're in common use and they cannot be banned in Heller. So here you have the Fourth Circuit and Maryland saying, oh, you don't understand. We need to have a trial. We need to have evidence. We need to put, cross-examine and get these people on the stand and, do all this trial work like we're Matlock. Right? Okay. You don't need that. That's hooey. Don't believe me. Heller is a gun ban case that was decided with no trial at all. No findings of fact at the trial level. It was decided on a record based on a motion to dismiss, where there had been no discovery, no facts, nothing taken. Same with Bruin, same with Caetano, same with Rahimi, same with McDonald. None of these things arose after a trial, and yet the Supreme Court was able to resolve these Second Amendment questions no problemo. Easy. So when you get this Maryland going like, oh, I want some cheese with that wine. We need this. No, you don't. The Supreme Court has never needed in the past in the 5 Second Amendment cases they've decided in the 21st century. And you don't need it in Snope either. That's just a bunch of hooey and an excuse to delay. But here's the kicker. Those delay tactics, hoping that Justice Alito or Justice Thomas will leave the court, and you swap them out for Justice Brown Jackson, have failed them. Because the next round of justices, whoever gets replaced on the court by Donald Trump or whomever, you're going to have young versions of conservatives and originalists as opposed to judicial activists like Justice Brown Jackson. So the strategy by the anti-gunners and the left in America to delay, hoping to change the composition with the court with another 4 years of Biden or Harris, that obviously has failed. Thank God. The only other point I want to make that Maryland argues this, and I'll put a link to their brief down below, is of course they go exactly where I told you they were going to go, exactly as I predicted, which is why I wrote the definitive article in the Harvard Journal of Law and Public Policy explaining why you cannot use the language in Bruin about unprecedented societal changes or unprecedented technological changes to justify banning any kind of firearm. Because the only arguments there is we have new technology that makes it easier to engage in mass shootings. This is the argument the Fourth Circuit talked about, the majority. This is the argument that, again, Maryland talks about. But if you look at the language they're trying to hook their hat on, the legal language from Bruin, it specifically says, in cases other than Heller and Bruin, you may have to use, when you're identifying historical analog laws, more subtlety or more nuance if you're dealing with some new technological change or societal change or something like that. But that is not the case because the language of that Bruin sentence itself specifically excludes from that language of unprecedented societal change, unprecedented technological change. It specifically excluded Heller, and Heller, of course, is the arms ban constitutional test. That's where the test comes from. Beyond that, as you know, Heller was decided in 2008. In 2007, we had, unfortunately, the Virginia Tech shooting, where you had someone that used a modern semi-automatic handgun with magazines that held more than 10 rounds to kill many people at Virginia Tech in the year of our Lord, 2007. Heller was decided in 2008. Bruin was decided in 2022. Therefore, you know what I'm about to say. Mass shootings, as well as modern semi-automatic weaponry, is not an unprecedented societal change or an unprecedented technological change Why? Because it occurred, all that stuff existed and was existing and was occurring in 2007 and earlier. Unprecedented means it's never occurred before. You can't argue that mass shootings are unprecedented in the year of our Lord 2024 when they existed in 2007, even before the Heller case was decided. You can't argue that semi-automatic rifles like AR-15s and AK-47s are some sort of unprecedented technological change when they actually are older than like I am. These are like 60 some odd years of old. This is 60-year-old technology. This is hardly unprecedented. We've had semi-automatic weaponry for 60 plus years in the United States. This is not an unprecedented technological change, and nor is mass shootings. We've had mass killings since the founding. Since Enoch Brown was killed in a schoolhouse in Pennsylvania by marauding Indians. Nevertheless, Maryland skips over a lot of this stuff. They don't mention it because they can't. It doesn't do them any good. So they're trying to get the Supreme Court to not touch this case. But I think it's time for the Supreme Court to hear the Snope case and fix this once and for all. The anti-gunners have been getting away with flouting the Supreme Court precedent. They've been thumbing their nose at the Supreme Court. And the fact is that you've had all these new anti-gun laws and gun bans dealing with AR-15s that have arisen post-Bruin. Just goes to show you. That's right. Those blue state governors like Kathy Hochul and Governor Pritzker and Governor Newsom, right? They are thumbing their nose at the U.S. Supreme Court. And I assure you, the U.S. Supreme Court knows this. And it's time for them to step up and do the right thing. And this election should only embolden the Supreme Court to realize that it's time for them to protect the Second Amendment robustly when it comes to these AR-15s. We just had an election. The pro-gun, pro-Second Amendment Americans won the White House. They won the House. They won the U.S. Senate. That's right. It's time for the Supreme Court to finally, once and for all, tell the lower courts what they meant in Heller, apply it to AR-15s, apply it to semi-automatic rifles, the most ubiquitous, popular rifles in the United States. Get it done. No more delay. The time is now. Supreme Court, get it done. And I don't think this Maryland brief is going to persuade the Supreme Court not to do it. The question is, will the Supreme Court have the fortitude to step up and do the right thing and enforce their laws and their precedents or not? I can't control them, but I know what they should do. And we'll see what happens. Again, we think we'll know about this in early January. But until then, we just have to see what happens. All right, folks, so there you have it. Hope you enjoyed the show. Make sure you follow me on X. I have over 19,000 followers on X at 4 Boxes Diner. Please subscribe to this channel. Like this video. Share with other people. Feel free to share the video, embed it, and show it around. Trying to grow the channel, of course, and make it more popular. And look forward to seeing you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.